Good morning. My name is Rita Fuller. I am DPI's Family Engagement Education Consultant as well as WSB's Grant Director. We would like to welcome you to the Foster Care and Rules Around Public Education webinar. We have three fantastic speakers: Mark Mitchell, DPI's Foster Care Consultant; Emily Tofty, Section Manager of the Department of Children and Family Services; and we have Tim Baroud, WSB's Family Engagement Education Coordinator from CESA 6 and Foster Parent. At this time, we'd like to turn it over into Caroline Rossing's hands, who is WSB's Grant Coordinator.
Good morning, everyone, and welcome to our webinar. I'm Caroline Rossing. I'm the Wisconsin Statewide Parent-Educator Initiative Grant Coordinator, and we've worked with these excellent folks here to put this informational webinar together for you. I just wanted to mention that we will be moving through the webinar without stopping at all today. But in the side panel of your screen, you will see an area that says questions. If you click on that area of your control box on the right-hand side of your screen, you'll be able to enter in questions as we go along. We will be monitoring those questions, and if they fit into the presentation that we're giving, the topics that we're on, we'll try to answer those at that time. Otherwise, we will take a look at those at the end of the webinar and try to answer as many of those questions as we possibly can. Also, I wanted to mention to you that if you missed part of the webinar today, it will be recorded. You, as a registered participant, will receive a link to that recorded webinar along with any additional handouts. So if you miss anything, don't worry about it. You'll be able to listen to it later. Going back to the slide now that's showing for you, I wanted to extend special thanks to Rita Fuller, our WSB Grant Coordinator, Katie Sapinski, who works in Adoption and Interstate Services section at Department of Children and Families, excuse me. Jillian Young also helped us out. She works also in the Department of Children and Families as a program and policy analyst. Whitney Golding, Waushara County Family Care Coordinator, has helped us out. Evelyn Asbell is our WSB Family Engagement Coordinator and Technology Coordinator, so she has coordinated all the logistics with the GoToWebinar today. And Sherry Silla is our CESA 1 WSB Family Engagement Coordinator, and we wanted to extend thanks to her also. The objectives for today would be a basic introduction to foster care and general rules around foster care. So an overview of this webinar would be rules around and roles and responsibilities of foster care parents in schools, rules around transportation, rules around pupil records, and rules around sharing of information. I'll now hand it over to Tim Baroud. He is a WSB CESA coordinator in CESA 6, which is located in Oshkosh. So he will start us off this morning with our webinar presentation.
Good morning, everyone. I'm going to start off this morning with some general foster care information to set the groundwork here for our webinar today. Some general rules and information for you to better understand it before we get into the rules around public education. So I want to start with some statistics here from Wisconsin. First is that 70% of the children who enter Wisconsin's foster care system are successfully reunited with their birth families. Reunification is almost always the primary goal for children entering care. When children cannot be reunited and adoption becomes the primary goal, 80% of children find permanency with relatives or the foster parents they currently live with. This speaks greatly to the bond that can form between children and their foster or kinship parents. If reunification with the birth family isn't appropriate as determined through our judicial system, adoption by the current foster or kinship parents is the next best outcome for these children. When adopted, they don't have to experience the trauma of separation from family a second time. Some reasons for children being in foster care, you may know some of these, of course, but they include neglect, physical abuse, sexual abuse, or parents who are in jail or hospitalized with no one else to care for the child. So what is foster care? Well, foster care is home-like care provided by licensed foster parents for children who cannot live with their parents because they either are unsafe, have special care or treatment needs that their parents are unable to manage, or other circumstances resulting in their parents or family being unable to care for them. For instance, what was mentioned in the last slide. Foster parents play a critical role for children, families, and agencies. The foster parent's primary task is to temporarily care for a child until the child's permanence goal is achieved. This includes not only providing a safe home, but helping children make sense of their world and the circumstances they are a part of. It involves helping the children handle the grief and temporary loss of their home and family, taking care of their medical needs, learning how to cope in tough situations, and working with the school to ensure the child is successful. Of course, foster parents are expected to comply with agency requirements, licensing standards, and important communication. We will briefly explain agency requirements and licensing standards shortly. Foster parenting also means working in partnership with the child's family, the agency, and, if applicable, the child's tribe for our Native American children. It is important to note that foster parents are part of a system of support for parents who need to make changes for the safety of their family. Sometimes foster parents are perceived as being the bad guy because the children are taken out of their home and placed with the foster parents. It is very important that, when appropriate, foster families build a positive relationship with the parents to help them in their journey to reunify with their children. Some places call this shared parenting. When the foster parents are able to work in partnership with the family and not in isolation, the outcomes are better for the parents and the children. Letting the parents know that the foster family is just here to help is very important, and the relationship that can form is invaluable as a tool for families to build a safe home for their kids and ultimately reunify with them. When children arrive, transportation is actually written into the code, the foster care code, but this becomes a difficult area to navigate sometimes. Unfortunately, caseloads make it difficult for agency staff to assist with visits and appointments regularly, but on occasion they can assist. Oftentimes, agencies ask that foster parents assist with rides to visits, but will for sure be required to get the children to medical and dental appointments. And oftentimes this is done in conjunction or in partnership with the parents. Code requires that you make health appointments for the children in the first 30 days of placement, but not necessarily that the appointment has to fall within the first 30 days, but it needs to be made. Team meetings keep everyone on the same page and allow for group brainstorming. The frequency of team meetings varies depending on county and agency. And finally, foster parents should keep documentation of significant happenings. Keeping a log or calendar to note behaviors around visits, completed or missed phone calls, etc., is very important information for any questions that the placing agency may have. At the IEP team meeting, so the school invites us once they have signed written permission from the parents for us to be able to attend and be part of the team. It's a requirement to get permission from the parents to allow attendance by the foster parents. Because we have special knowledge and expertise on the child, our input is very valuable. The form that is used to get permission for foster parents to attend an IEP meeting is called the request to invite others with knowledge or special expertise to an IEP meeting. In inviting a social worker, you must also get permission from the parents to invite the social worker to the IEP meeting. This is done through a form called the request to invite outside agency representatives to the IEP meeting. One thing to note is that social workers are not allowed to make educational decisions or sign any special education paperwork. They are not to be used in place of the parents. We will spend some more time later in the webinar explaining who may act as a parent in the IEP team meeting when it's necessary. So how do foster parents get licensed? There's a list of things here that foster parents do have to go through to become licensed. Background checks are very thorough. Local police departments from the last 5 years, depending on previous addresses, foster parents are checked. County sheriff's departments are checked. The Department of Justice. Fingerprints are done through the FBI, Child Protective Services, and Sex Offender Registry. The home study is essentially personal interviews and information about your home and family that get condensed into one large document. It is a lot of paperwork that asks, it seems, about everything. It really feels quite invasive, as it should be, because it is important to make sure that every foster home is a safe place for children. We will discuss home safety on the next slide. And as a note, these licensing requirements are governed by Wisconsin Administrative Code, Chapter DCF 56. So the home environment is next. Oftentimes, parents who are considering becoming foster parents don't feel their home is acceptable for fostering children. It doesn't matter what type of home you live in. You can live in an apartment, a trailer home, a mansion, or a duplex. You just need to meet the basic safety standards addressed in Chapter 56. So regardless of the type of home you live in, a couple examples of things that are necessary are furniture. Can it be pulled down so where a child could get hurt? Small breakable items that can easily be swallowed. Some people may call that child-proofing your home. Weapons have to be secured in a locked cabinet with no glass doors, and ammunition has to be stored in a separate locked case. Smoke detectors, carbon monoxide detectors, and fire extinguishers have to be present, and the fire extinguishers have to be easily accessible on each floor. A fire evacuation plan and an emergency phone number list has to also be easily accessed. Of course, foster parents go through some training, and that's necessary to prepare foster parents and help them to continue to develop as foster parents. So being a successful foster parent means continuing to learn through classes and other training methods, reading books or magazines, talking with other foster parents. Sometimes this can include being part of a support group for foster parents in your community, and also continually developing new skills. There are many ways for foster parents to get the training they need, and there are our requirements as well as far as the amount of training necessary for foster parents. So at this time, I'm going to turn it over to Emily Tofty from the Department of Children and Families to go over some of the training requirements and levels of home with you.
Thanks, Tim. For those in the audience, just wanted to give you some background. Prior to coming to the Department of Children and Families, I did foster home licensing for a number of years through a private agency. So it's part of the reason that I'm covering this information. But with regard to training requirements in particular, there are very specific requirements that are based upon a foster parent's level of certification. So we'll go through that chart in a little bit, but essentially, regardless of the level that you're licensed at, you are required to do pre-placement training, which means that you have to complete that training prior to a children entering your home. Initial licensing training, which occurs during the first period of time at which you have your license, and then ongoing training, which occurs during each licensing period after that. So for example, the training requirements for a foster parent at a level 2, next slide, oh, there we go, is 6 hours of online interactive training prior to becoming licensed, 30 hours of foundation training, which is a standardized curriculum that has been prepared, so all foster parents get the same information, and that has to occur in the first 2 years of becoming licensed, and then 10 hours of ongoing training every additional year that you're licensed. So this chart represents the levels of care or levels of certification for foster parents. The level 1 certification is specific to individuals who are licensed for a particular child. So for example, if a teacher wants to become licensed for a child that she has relationship with or he has relationship with, they could do this through level 1 certification. Level 2, which we just mentioned, is kind of your standard foster care level of certification. It's described as a basic level. Counties are usually responsible for licensing level 2 providers, and typically kids with needs that are similar to other children developmentally are placed in level 2 homes. So the children may need some additional support from day to day because of the impact of trauma on their development, but their need for formal treatment is usually less. I say that with recognition that a lot of our children who are placed in level 2 homes have pretty complex trauma needs, and because of the shortage of resources, a lot of kids in level 2 homes could possibly be served in level 3 or 4 homes, but they're just provided, the level 2 providers are given additional resources to support them in the level 2 certification. Level 3 and 4 providers used to be considered treatment foster parents by the state, and to be honest, that name still exists in the field amongst providers and those licensing those foster parents. Those foster homes do accept children with more significant needs, and they're supported differently by the placing agencies because of that. Most level 3 or 4 providers work closely with a private child placing agency and also a county agency to support the child in their care. And for example, children with a level of care of 3 or 4 require a formal treatment plan. They also get more frequent visits by the assigned caseworker and ongoing treatment team meetings for reviewing the child's progress on their treatment plan. The agencies are required to offer 24/7 support via a crisis line to level 3 and 4 foster families. They also need to offer respite support and whatever additional supports might be needed to ensure the child has a stable placement that's meeting his or her unique social, emotional, mental, and physical health needs. I'm going to turn it back over to Tim to talk more about the resources and support that foster parents are provided.
So for foster parents who have children in their care, these are some of the resources and support they are offered to help take care of those children. Monthly reimbursements can cover things that come up periodically, such as sports equipment and fees or driver's ed course fees after proof of payment has been submitted. Mileage for transporting foster children can be reimbursed if the foster families complete the required documentation each time. Daycare assistance is available for foster families who need it. And the newly passed prudent parenting law allows for foster families to make decisions for the foster child that encourage normal childhood experiences. The foster families must use good discretion and take into consideration many other things when making decisions for the child. This includes past history, people likely to be present, and any necessary safety issues, and also cultural considerations. So this is some of the basics of out-of-home care. Next thing we have here is respite. So respite is a really good way for new foster parents to get their feet wet. It typically will be 1 to 2 overnights. Oftentimes it is a weekend for 2 nights. Respite can be for foster children, or it can be for children from the community as a method to prevent removal and support local families. So it doesn't have to be simply for children who are already in foster care. Also, respite doesn't follow quite as stringent of requirements as level 2 foster care does. So children in need of respite have a little different rules as far as the home and the home surroundings to be able to stay.
Here's a slide for questions, but as I said earlier, we'll continue moving on through the presentation and take those questions at the end unless we're able to fit one into our topic area. Thank you. So now we'll move on and we'll have Mark Mitchell from the Wisconsin Department of Public Instruction continue on for us.
Good morning. We've talked and we'll be talking sometimes in a little jargonese, so we want to get some definitions out of the way. Depending on what you're reading or looking at, you might see something called out-of-home care or foster care. For our purposes in the state of Wisconsin, we've been trying to use the term out-of-home care rather than foster care, which is the term that the federal government uses, because foster care sort of implies what Tim and Emily have been talking about in the sense of, you know, 2 parents in a home with 1 or 2 foster kids. But out-of-home care, which incorporates that, also includes what, as Emily pointed out, used to be called treatment foster homes, group homes, which generally speaking are for 5 to 8 kids, usually a little bit older, a little bit more complex needs. Residential care centers, which pretty much handle the kids that have the highest treatment needs. Shelter care facilities, which are generally short-term. You know, if a kid is homeless, they get put in the shelter care, or it's an alternative to a juvenile detention facility. Another one is the home of a relative who isn't a parent. So it could be Aunt Martha. Or the home of a non-relative where the child is under the placement and care responsibility of the Department of Children and Families or a county or tribal child welfare agency. Basically, these are generally short-term, and once the time limit is up, within the time limit, they'll either be going back home or placed in a more permanent out-of-home care facility. So just a reminder, if you see something from the federal government that says foster care, or if you see something in Wisconsin that says out-of-home care or foster care, generally speaking, what we're talking about is out-of-home care, the whole gamut of types of facilities. Under the federal Every Student Succeeds Act, it's required that children be maintained in their school of origin whenever they're placed in out-of-home care. So the school of origin is the school in which the child is currently enrolled or was most recently enrolled at the time of the child's placement into out-of-home care. An individualized education plan, or IEP, I think people pretty much know what that is. It does come into play with a lot of kids that are in out-of-home care. The resident school, as opposed to the school of origin, is the school in the district in which the child's out-of-home care placement is located. We'll talk about the Every Student Succeeds Act in a little bit more, but under that act, the presumption is that when a child is placed into out-of-home care, he or she will stay in the school of origin. That presumption can be overcome by the schools involved and the child welfare agency making a best interest determination that it would in fact be best if the child went to the resident school. I should point out just that if the child does go to a resident school and then his or her placement is subsequently changed again, then that resident school has now become the school of origin. Best interest determination is sort of a confusing area these days because for a long time child welfare agencies have been required to make best interest determinations, and the judge has to make a finding of the child's best interest as it relates to all of the factors in Chapter 48 when a child is at a dispositional hearing. So whether or not the child goes into out-of-home care, there's a best interest determination that looks at the overall aspect of the child's life with the parents, and the judge makes a determination on what happens with that child. Under the Every Student Succeeds Act, there's now another thing also called a best interest determination, solely related to the issue of whether the Department of Public Instruction and simply means that we in their origin when possible. But it goes beyond that, and we'll be looking at reducing suspensions and expulsions. We'll get to some data related to some of these things in a little bit. the transferring and accrual of credits. When kids do change schools, they may be halfway through a history course and then get placed in another school, and that class is halfway through a different history course. So oftentimes the kid in out-of-home care ends up not getting any credit for any work he did in either one of the classes. So we want to take a look at that, and that will help us get to higher graduation rates.
Audio is cutting in and out.
Is there anything we can do about that?
Message Caroline.
She did.
Okay.
We seem to be having some difficulty with the sound. We're trying to determine whether or not everyone is able to hear us at this point. Okay, so Evelyn says it is better now.
Okay.
So we'll continue on. Move the volume up a bit. So we'll continue on. So we do have Evelyn, our technology coordinator, overseeing this. So if we have sound issues going forward, we'll address those as needed. So thank you, Mark. Sorry for the interruption, but go ahead and continue on.
Very good. We just wanted to lay out some statistics to help you understand why our working to improve the lot of kids in out-of-home care is so important. 56 to 75% of kids, when they go into out-of-home care, will change schools. 38% of children in care have experienced one or more school changes. 11% have experienced two or more school changes. I was just talking to a school the other day where they're trying to figure out what to do with a child who is in 9th grade and has gone to 8 different schools in the course of being in out-of-home care. There's been a study which indicates that a child loses 4 to 6 months of academic progress with each school change. So it's certainly no wonder that a lot of these kids never feel a sense of belonging. They have a tendency not to graduate on time. And to a certain extent, that affects their whole life. No question about that. 57% of Wisconsin children in out-of-home care will graduate high school. And I mentioned one of the things that we want to look at is reducing suspensions and expulsions, because kids in out-of-home care are twice as likely to be suspended and 3 times as likely to be expelled. And they are 2.5 to 3.5 times more likely to have an IEP. In my view, one of the saddest pieces of data, because it relates to the hopes of these kids, is that 84% of kids in out-of-home care say they want to go to school, to a post-secondary education. 50% of the youth in care who complete high school by age 18 actually go on to college. 20% of youth out-of-home care start a post-secondary education. I'm sorry, I think my second statistic, it's 50% of youth in out-of-home care complete high school by age 18. And again, a lot of that's due to the loss of academic progress when they move. 20% start a post-secondary education. Only 2 to 9% of youth in out-of-home care who start a post-secondary education will earn a bachelor's degree. So we go from 84% who want to pursue post-secondary education down to 2 to 9% who will actually earn a degree.
So if those statistics aren't depressing enough, we do have other outcomes for kids who are placed in out-of-home care, some of which are associated with trauma and some of which are associated with their experience in out-of-home care in general. So oftentimes what we find for kids, particularly who are in out-of-home care in their teen years and potentially age out, is that they're encountering homelessness when they leave care. There's a lack of stability and permanency for those youth in particular. They have a difficult time finding employment, and when they do find employment, oftentimes it's low-paying jobs, which increases their risk for exploitation, certainly poverty, and they have a difficult time establishing independence. Many of our kids have no career counseling, so 75% is the current statistic, and 50% have no training or job applications or interviewing experience. In addition, because of their trauma histories and often a family history of substance use, our kids are at higher risk for substance use and abuse, illegal drug use, for the purposes of experimentation and peer pressure, which is pretty normal in way of teenage development, but also for needs of self-medication due to a lack of health care or coping mechanisms for stress. Many of our youth experience unexpected pregnancy, depression, mental illness, anxiety, and a variety of other mental health concerns. With regard to need changes, we're definitely looking at having the collaborative relationships with secondary and post-secondary educators, healthcare providers, career counselors, juvenile justice, which we at the Department of Children and Families are now referring to as youth justice, and child and family services, a vast array of community providers. The more we talk, the more kids win. That's to quote John Bly, who is a member of one of our collaborative groups for post-secondary education. With regard to the implementation of the Every Student Succeeds Act, it's important to note that this is just one piece of federal legislation in a line of pieces of federal legislation that has taken another stab at trying to rectify these issues and have better outcomes for our youth. So particularly back in 2008, the Fostering Connections to Success and Increasing Adoptions Act was implemented, which said, okay, for the court's purposes, a child's permanency plan must include assurances that the placement of the child takes into account the appropriateness of the current educational setting and the proximity to the school. So it was looking at, when possible, can we place kids in their school of origin or near their school of origin to ensure that consistency. So that was definitely a step in the right direction. In 2013, the Uninterrupted Scholars Act came into play. It amended the FERPA legislation and required sharing of educational information by the child's school with the child welfare agency that had placement and care responsibility. So really this act was saying it's great for the children to be in school, but regardless of whether in their school of origin or school of residence or something else, just having them in a school is not enough. You guys need to talk with one another. So then came the Every Student Succeeds Act, which kind of raised the bar for folks with that sharing of information piece and said, not only do you need to talk with one another, but you need to work together so that kids have better outcomes. So this became effective on December 10th, 2016, and Mark and I have been working very closely together since then. I think I'm at the DPI pretty much on a weekly basis. And what we're really trying to do is make sure that all kids in out-of-home care who are enrolled in public schools have the resources that they need and that they have the child welfare workers and educators prepared to meet their needs in the educational setting. It also requires written transportation procedures and makes sure that folks who are involved in getting the child to school, and that includes both the school and the child welfare agency, understand how they're going to partner to have that happen. In addition, the federal legislation said if a child welfare agency identified a point of contact to the school district, they should identify a point of contact back so that they would have kind of an even playing field of folks who would participate then in creating procedures that we'll talk about. So at a department level, the Department of Children and Families and the Department of Public Instruction said, that just makes things really cumbersome. Let's take a step in the right direction and just have all child welfare agencies and all local education agencies identify a point of contact so that nobody's waiting for someone else to initiate that. So we did do that, and we have compiled lists of points of contact which are now stored on both of our websites. So we have a foster care point of contact, and that person is at the school, and it is the person that a child welfare agency can meet with to talk about how a child's experience in foster care is going to work with the child in that school. There's also an education point of contact, which is a person at the child welfare agency that educators can go to talk about how the child's experience in out-of-home care is going to impact them at school. So those lists, going back to that slide real quickly, when you have this PowerPoint in your possession, you can click on those hyperlinks and be directed to those lists and easily identify who at your child welfare agency, including county and tribal child welfare agencies, or your local education agencies have been identified. We have the majority of child welfare agencies and tribal child welfare agencies, and I believe all 422 school districts with a point of contact.
Yeah, I just, one addition to that is that our system now is that if the point of contact at the school changes, rather than, it used to be they would notify me and I'd borrow some people to help me get into the system to change it. Now it's changed through the school directory process change, so it's changed at the local level. I should point out too, the federal law required that the Department of Children and Families and the Department of Public Instruction each identify a point of contact. For Department of Children and Families, it's Emily. For Department of Public Instruction, it would be me. Purpose of the points of contact, to meet, discuss, create policies and procedures. Emily mentioned the written transportation policies. That's something that is very specifically required by, I think from now we'll switch over to ESSA, so it's the Every Student Succeeds Act, that every local educational agency, in collaboration with the child welfare agency, but it is the responsibility of the school to develop transportation policies. One of the other things we want them to do is discuss the process for making those best interest determinations about where the kid will go to school. Making sure that the transfer of records is immediate. The federal law requires that children be enrolled immediately and that the school that the child will be attending request the records from the school of origin immediately. I should point out, we don't know what's going to happen. There is a bill that's been introduced, or will be introduced soon, in the legislature, that under the current law, when there's a transfer of records request, the school has 5 days to do it. The federal law says it must be done immediately. So our DPI's interpretation of that means within 1 day. And if this bill passes, that change would be made to the law. Sharing of data generally, provision of transportation during disputes. If in the process of the child welfare agency in the school not being able to immediately figure out how Johnny's going to be transported every day for the semester, the federal law requires you can work on that all you want, but somebody's got to get Johnny to school tomorrow. Yeah, so the transportation policy has to include that. Basically, ensuring that students are enrolled and regularly attending, and professional development and training. I just want to point out that what we're talking about with the points of contact is more of the high-level systemic issues between child welfare and the school. We don't want the points of contact to necessarily be getting down to the level where the school social worker and the child's caseworker should be talking about case specifics. The purpose of the points of contact was to be more policy procedure oriented rather than specific case. I should also point out that Emily and I will be working more on this. One of the issues for us, of course, is that as the schools began to appoint points of contact, we kept track of what type of person was being identified, and it was all over the place. One school district, it might have been the school district administrator. In one, it was the school social worker. Another was the head of pupil services. So we recognize that the baseline knowledge of some of these people is not the same. So in terms of how Emily and I relate and how points of contact at the local level relate, we're going to be doing more work on that.
And it's safe to say that that's the same with tribal and child welfare agencies as well, because we've got a variety of different agencies who have a variety of different resources. So in some counties or tribes, you will have the foster care coordinator be identified as a point of contact, and in some you'll have it be the director. And they obviously have very different roles and very different time commitments.
I want to just talk for a couple of minutes about the overall responsibility of the LEA related to children in out-of-home care. Primary among them is to collaborate with the Child Welfare Agency on determining the child's best interest. The ESSA is, if nothing else, focused on collaboration between systems. That is the primary thing that is supposed to result from implementation of the law. The LEA also has to immediately enroll the child in the appropriate school. The resident school, as I mentioned, immediately requests records. School of origin immediately sends records. It should be pointed out that for kids in out-of-home care, even if the school does not have all of the paperwork that's normally required to enroll a child, for example, a birth certificate or transcripts from previous schools, the enrollment must happen immediately. The child must be served immediately while all of those documents are being put together and sent. They should review all available information provided by the Child Welfare Agency, and then with the Child Welfare Agency develop those clear written procedures regarding transportation we talked about. And just to emphasize that, how transportation will be provided, arranged, and funded, and which agency will provide transportation until a permanent plan is developed.
So for child welfare agencies, in some ways, this hasn't changed things a whole lot for them, because they've been required since 2008 to assess the appropriateness of current school placement and proximity to school. What has changed is that they now need to work with their educational partners to make another best interest determination to really ensure that they're factoring in whether or not the school of origin or the school of residence is the best place for that child to be. In addition, they need to refer children for enrollment in school, in the resident school if that's necessary, and then follow information that's included in a caseworker desk guide that was put together by the Department of Children and Families to assist child welfare agencies in completing the ESSA requirements. So between the Departments of Children and Families and the Department of Public Instruction, we are working to collaborate and to assist our local education agencies and child welfare agencies by providing them with guidance, which we've already issued some, and we'll get into that in just a little bit. We've developed some sample procedures to assist folks, and then also are providing technical assistance through the implementation of ESSA, and my guess is from now on, this is kind of this, which is a great change, but together we will be responsible for ensuring that there are better outcomes for our kids. The best interest factors and determination worksheets are available, as well as the transportation procedures and plans online. And we will have resources at the end of the presentation. We have a frequently asked questions document that is in the process of being revised. It's near completion. We will just have to have it reviewed by legal counsel and make some final edits. Given that legal counsel is often very busy, it may not come out until, you know, my hope is the first quarter of 2018, but hopefully that will be out soon. And then we're also trying to share successful models of collaboration, including looking at other states to see what they're doing.
If I could just interrupt 1 minute, the document that Emily is referring to, the frequently asked questions, it's
large?
No, well, that too, yeah. It's entitled Educational Services for Children Placed in Foster Care. That's the one that we're changing, and I don't know, I think it has 78 questions, or there's a lot of information. For those of you familiar with other DPI publications that are also in the frequently asked question format, some of our answers that we're changing in this document, those questions are also in some other documents, so there's going to be a ripple effect, and it's going to be, the whole process is going to become more dependent on having them online rather than the current printed booklets, because they will be outdated in short order.
All right, so getting into the best interest determination then. When we're talking about making a best interest determination and encouraging child welfare agencies and schools to talk with one another to make that determination, we're really saying, with regard to this particular child, are there preferences of the student, the parent, or any educational decision maker about where this child goes to school? Are there any safety concerns that need to be taken into consideration? What are the child's educational needs and strengths? And what's the expected length of placement? If a child is going to go somewhere and it's likely because, let's say the issue is the parent is incarcerated and we know the parent's getting out of jail in 6 months, it may not be in the child's best interest to move to a school of residence for 6 months. And so it may be best to keep the child in the school of origin and make some sort of special transportation arrangements. Similarly, the permanency goal should be factored in. If we know in advance that a child is likely to go towards adoption, let's say a parent is verbalizing that they are interested in terminating their parental rights, they don't believe that they have the capacity to care for their child, it may make more sense to relocate that child to the school of residence if that's also going to be the child's adoptive resource. School attendance and transfers, certainly the number of time a student has moved should be taken into consideration, as well as their ethnic, cultural, and linguistic needs. The attachment to the school, if a child has been at that school for a number of years, separating them from that school can be almost as traumatic as separating them from their family. So if they're attached to that school, we want to try and make it as feasible as possible for them to remain in that setting. The timing of the transfer. If we are 2 weeks from the end of a semester, let's not look at changing the child's school. Let's work at getting them through until the end of that point and then making the decision about where the child will attend the next school year. School attendance by siblings. The majority of the time, we're able to work together to keep siblings together. That said, that doesn't always happen. And if children can at least be maintained in the same school as their siblings, that provides an informal way for them to have connection, and that is incredibly helpful. The length of time that a student has to commute to school should also be considered in looking at their age and also their motivation. So we had a youth who was a teenager who was placed approximately 40 minutes from her school, and she took 2 different buses each day to get to her school of origin, and was successful in graduating on time because she was willing to do that. She did not want to change schools. She was very attached, and that was the best way to get her there. And she was also developmentally at a point where that was feasible for her. And finally, looking at all of these things in the context of how a school change is going to impact the credit transfer, credit accrual for our kids so that they don't lose the credits they need in order to graduate. Mm-hmm. We really want to emphasize that with all of these considerations, you'll notice that money isn't talked about. So the cost of transportation is not to be considered when determining the best interest of the child. We know that financially it is something that agencies are considering all of the time, and unfortunately ESSA did not come along with any additional funds for either the Child Welfare Agency or our educational partners. So while we understand it's a real challenge, it's not something that can be considered or a reason for moving a child. If there is disagreement about the best interest, the joint federal guidance has indicated that the local child welfare agency should have the final decision-making authority, mainly because they're better positioned to have all of the information about it, what's going on with a child, their family, their permanency outcomes, and how that relates to their education.
I just want to add to that just a little bit of the historical piece with ESSA is the non-regulatory guidance that Emily mentioned does in fact say that ultimately the Child Welfare Agency has the authority, because ultimately the judge has the authority to a certain extent. When the federal government came out with their draft regulations related to ESSA, it was very clear that the Child Welfare Agency should have the major authority. After receiving all of the comments from states, they took that out in the federal regulations. It's not in the law. It wasn't in the final regulations, and then the Trump administration pulled those final regulations anyway. So basically the non-regulatory guidance from the issued jointly by the U.S. Department of Education and the U.S. Department of Health and Human Services indicates that its Child Welfare Agency has the ultimate responsibility. In terms of the transportation, obviously the major implications are the mechanism for getting the kid from one place to another and the cost. When we talk about a shared responsibility, and ESSA is very clear that these kids are a shared responsibility between child welfare and the schools. And that includes the funding for the services necessary to get the kid to school. But when we talk about that, when the school and the Child Welfare Agency are figuring out how they're going to split the cost, what we're talking about is additional cost. So, and these numbers are ridiculous, and I admit it, but I'm using them as an example. If it would cost $5 a day for the resident school to get the kid to that school, because that's where the foster home exists, but in order to get the kid to the school of origin, it costs $25 a day. What's being negotiated between the Child Welfare Agency and the school is the $20 that's additional above and beyond what it would cost to get to the resident school.
Can I interrupt you for 1 minute? Mark, we do have a question from a participant. And Emily, if you two could speak to this question a bit if possible. The question is, who should facilitate information sharing about report cards, etc., to parents? Foster parents often don't have contact with the child's family. Do you have any thoughts on that? Or
we will be getting to information sharing in a little bit, so maybe we just hold on to that until we get there, if that's okay.
Okay, sounds good. Thank you very much.
As I mentioned, the ESSA, one of the few things it specifically requires is for the child welfare, for the school to develop the clear written procedures. Those procedures have to talk about how transportation will be handled, how a dispute will be handled, and which agency will pay any additional costs incurred in providing transportation. It's on our website. The Department of Public Instruction recommends all things cost for transportation should be split 50-50 between the school system and the child welfare agency. So if both the school of residence and the school of origin decides they're going to contribute to the cost, then maybe they would each be 25% and the child welfare agency would be 50%. It does depend on if there are any other circumstances. For example, if the kid has an IEP, it may well be that travel is a provided service. So in that case, it might be the school paying 100% of the transportation cost. In other situations, it might be that the foster parent says, don't worry about it, I'll take the kid to school every day. In which case, the cost is 100% with the out-of-home care provider or the child welfare agency, which may reimburse the out-of-home care provider. But in those situations where neither one of those is the situation, then we just recommend splitting it 50-50. In terms of those written procedures, it's important to recognize that Wisconsin has 72 counties, 422 school districts, and 11 federally recognized Indian tribes. If you consider that many counties have multiple school districts, and some school districts are in multiple counties, when you start doing all of the multiplication into how many different policy or procedure that could be, it's pretty intense. So DPI and DCF, as Emily mentioned, if you go to our website, there is some guidelines and some samples of written procedures, both in general in terms of how the child welfare agency and the school will deal with transportation. And there's also a model policy for a child-specific agreement. ESSA indicates that transportation should be provided in a cost-effective manner. I don't know that we need a federal law to tell us that, but in fact it does. So this could include by providing funding to the foster parent through the rate setting process that's used for funding out-of-home care. By providing funding to a group home as extraordinary payment, using volunteers as individuals or through social organizations. I know in some cities that there are elderly people that volunteer to be drivers for a variety of services. And existing school bus routes. One of the things that's been talked about is the school of residence could maybe get the kid to the closest place on the bus route that the school of origin could pick the kid up. So it's both school systems working together to minimize the hassle for the kid. The transportation to the school of origin has to be provided for as long as the child is not of home care. And that can cross the summer. So if the kid's in out of home care in June and is still there in September, then the whole transportation requirement is still there. Emily mentioned that ESSA unfortunately did not provide any funding for implementing the transportation requirements. For those of you familiar with McKinney-Vento Homeless Act, there was additional money for that, and schools could set aside those funds. Beginning in the current school year, schools can set aside funds for out-of-home care transportation. Again, it would be just reallocating your existing funds because there's no new money.
So to kind of wrap this portion up, to talk about the roles and responsibilities of school staff and child welfare caseworkers, we really want to emphasize that even though there are points of contact for each of the local agencies, we don't want that to impede the conversation that really happens between the people who are working directly with the child. So we want kids to, we want teachers, We want caseworkers to talk with one another about the child that they have in common. We have recently developed something called the Education Passport through the Department of Children and Families. That is a form the caseworker can print off once a child's record has been completed. So if a child is new to the system, it's going to take a little bit of time to get that case record complete and be able to share that information. But the Education Passport basically provides all of the need-to-know information to schools, and is something that the child welfare workers can share freely with the educational folks who need to know. We are workers to attend a child. We continue to necessarily permission form to have them at IEP meetings and just involve them as much as humanly possible because it's really important that they understand what's going on there. So we were going to pause for questions. I don't know if we want to do that at this time or not.
I guess I'll refer to Tim and Rita, who are monitoring those questions. Should we continue on, or do you see some questions that might pertain to this topic that we're at?
The only question we have is regarding who should be facilitating the sharing of this information. So if you want to answer that now or later.
Why don't we wait till the next break, because then we're going to start looking at some of the ability or lack of ability to share information between systems.
There are no other questions.
Okay, great. Thank you very much. So Mark will continue on here for us.
When we talk about disclosure of information, we're talking about permitting access to, release, or transfer, or other communications of personally identifiable information. That's a key. It has to be, we're talking about personally identifiable information containing education records to any party by any means, including oral, written, or electronic. That's, by the way, reference to 34 CFR. That's the Code of Federal Regulations, which is the equivalent of federal administrative rules. Essentially, there are 3 allowable situations in which disclosure can happen: with the written consent of the parent or guardian, by court order, or by authority of the statute. Parents continue to have full access and rights unless the school receives notification from the court that the parent has been denied these rights. This is important because in some cases, you know, let's just say, for example, the child's in out-of-home care because she was sexually abused by dad. Not only should the court have, you know, indicate that dad maybe should not have access to records, but on a broader scale, the court may say that dad should have no contact with the child. So the school needs to know that. And it should be pointed out that step-parents are not considered parents under Wisconsin statutes. There are a number of laws regarding pupil records. Probably the longest one, I think it was 1964, was the Family Educational Rights and Privacy Act, or FERPA. It was also called the Buckley Amendment back then. And then there's the Individuals with Disabilities Education Act, or IDEA. In Wisconsin, we have sections 115, 298, and 118, 125, both of which are Wisconsin laws relating to schools. Chapter 146 relates to medical records. There's the new reasonable and prudent parenting standard, which I think we're going to talk about. We're going to talk about that in more detail. And the Uninterrupted Scholars Act, which basically made some major amendments to the FERPA, the first one listed. And this, of course, is not an exhaustive list because oftentimes, I should point out that there are also privacy laws related to kids in Chapter 48, the Children's Code, and Chapter 938, the Juvenile Justice Code, on the child welfare and juvenile justice side of things. All records relating to individual pupils maintained by a school including any information recorded in any material in any way. This includes behavioral records, directory data, progress records, patient healthcare records, and pupil physical healthcare records. Generally speaking, what we're talking about here are what is defined as pupil records. The exceptions to this are personal notes created and used by educators. So if the teacher makes notes about a kid's performance in class or things that he or she noted that have significance in terms of how she's going to teach the kid, and there's no intent for those notes to be used by anyone else, those are accepted and don't have to be shared. The second is law enforcement unit records. And most of you probably know, but I just want to make it clear that what we're talking about here is when the school creates a law enforcement unit. It may be police officers from the local municipality, but they're serving in a unit created by the school. So we're not talking about law enforcement records in general. We're talking about records maintained by that unit related to the school. And psychological treatment records. The Uninterrupted Scholars Act of 2013, that's in short form, that's USA sort of blocked out there. The unauthorized disclosure of other people's records is permitted without consent to the child welfare caseworkers if necessary. I just want to point out that chapter 1, or the section 115-298 was created, and section 118.125 was amended by 2015 Wisconsin Act 161. To a certain extent, they seem to be conflicting. 115 sort of indicates that there needs to be an MOU between the school and the child welfare agency for records to be transferred when parents object. Whereas the language in chapter 118 allows the transfer regardless of whether the parent objects or not. We are talking about this to see if we can get some clarification there, but DPI's interpretation at this point is more in line with chapter 118, 125, where the records can be transferred. No MOU is necessary. However, it does make some sense for schools and child welfare agencies to enter into a general MOU about records, just because it could make the process cleaner, less hassle for everybody if such a document exists. It's interesting that schools cannot share records with out-of-home care providers directly without written parent permission. However, the caseworker can share the information with the out-of-home care provider.
So just to be clear, what this is saying is that the school can't share directly with a foster parent or a group home per se information without having that parental permission, but they can tell the child welfare worker, who can then share that information with the group home or the foster parent or other out-of-home care resource.
Yeah, it's something that we, another area where we're looking at maybe trying to get some clarification, because what the state law says is that the child welfare worker can redisclose the information to a person who has an interest in the child's education, etc. We, the two departments, have collectively interpreted a foster parent to be someone who's concerned about the child's education. Why it isn't a little more clear, I don't know. But our interpretation is that's how it works. Out-of-home providers can share information about the student with the school directly. but specific case-related information may not be shared.
So foster parents can come to the school and talk with the school about the child having a difficult night or any other experience that pertains to the child specifically, but they can't share that mom was just put in jail and that dad has missed 3 weeks of visitation, because that's case-related information and there really is no need to know.
It's one of the reasons it's so important for there to be good communication, because it may well be that Johnny today is great, he's learning well, his behavior is great. Tomorrow he comes in and he's a basket case. And it would have been helpful for the Child Welfare Agency, because the out-of-home care provider cannot share specific information, but the out-of-home care provider could say, yeah, tomorrow Johnny may be a little edgy. Whereas the Child Welfare Agency can say, there's a home visit for Johnny tomorrow. They usually don't go well. So he may not be his own perfect self tomorrow in school.
Most of the time it is the out-of-home care provider, though, that's having that daily contact with the school, not necessarily the child welfare worker, mainly because they have a few other things that are on their plate and many other children who are also in school, so it makes it a little unrealistic for them to communicate about those day-to-day things that might come up. So with regard to kind of the day-to-day things, Tim mentioned very early on the reasonable and prudent parent standard that came into play back with the federal Preventing Sex Trafficking and Strengthening Families Act of 2014. So essentially what this act allowed for is for out-of-home care providers to make some of the same decisions that parents would normally make without getting parental permission in order to provide some sort of normalcy for kids in their out-of-home care experience. So this applies to out-of-home care in the broad sense of the term, which includes foster parents, guardians, court-ordered kinship care providers, unlicensed relatives, group homes, residential care centers, and shelter care facilities. So with regard to the standard, out-of-home care providers are able to do things like sign permission forms or allow for participation in age or developmentally appropriate extracurricular activities, enrichment opportunities, cultural activities, and social activities. So kids in out-of-home care are able to go on field trips, they're able to watch films that their peers are watching, they're able to join sports or clubs through permission forms or consents that are signed by foster parents. I do want to emphasize here that while foster parents can do this, we never want to exclude birth parent involvement. And I believe, talk a little bit about the fact that our birth parents should continue to be involved just like they were prior to a youth being removed or placed in out-of-home care, as long as there's permission to do so. Most of the time, there isn't a no contact order in place, meaning that the child can't have contact with the parent. So 9 times out of 10, you're definitely able to keep the birth parent involved whenever possible. The other piece, this may be a good time to field that question with regard to who facilitates, and I just want to make sure that I'm summarizing it accurately. So it was who facilitates the transfer of report cards to the birth parents.
Let me read it for you, Emily.
Thank you.
Who should facilitate information sharing about report cards, etc., to the parents? Foster parents often do not have contact with the child's family. So
I would say that because Tim referenced shared parenting, that is definitely the model that we encourage, and so foster parents should be having contact with birth families whenever possible. But like I just stated, parental involvement really doesn't change when a child is in out-of-home care. So those report cards should be sent directly to the parent, and oftentimes the caseworker needs those for the purpose of submitting the information to court. So, and caseworkers can then re-disclose that information to the foster parents so that they have record of the child's report card as well. but whenever possible, continue to send that information directly to the parent.
I should point out that under Chapter 48, the Children's Code, when a child is placed into out-of-home care, the law says that legal custody should be transferred from the parent only when there is no less drastic alternative. So unless there's a very good reason to take legal custody away from the parent maintains legal custody and therefore has the primary ability to make decisions related to that child. I should also point out that it gets into sort of a philosophical approach, and some courts are more likely to transfer custody from the parent when they place a child in out-of-home care than others. So it should be assumed, though, if you're in a school and you have a child in out-of-home care, you should assume, until you are told otherwise, that the parent is the primary education decision maker.
And at the time of enrollment, if a parent's contact information is not provided, then you should be reaching out directly to the caseworker to obtain that information. And I don't know if it's possible to ask for that information from the school of origin with the transfer of records, but that parental information on the contact card or whatever should continue to be shared with the school unless you know that for some reason there isn't there's a no contact order in place. And just to clarify a little bit what Mark was just talking about, because it was always confusing for me, even as a social worker, which I was once back in the day. When children are taken into out-of-home care, it's temporary physical custody that's taken. So what they are able to make decisions about is the physical placement of the child. Mark referenced legal custody, which it relates to all other decisions for the child. So essentially, unless a court orders that the child welfare agency has physical custody and legal custody, the county child welfare or tribal child welfare agency is really only supposed to be making decisions pertinent to the placement of the child.
I also want to make clear that the physical placement of the child in that case does not does not pertain to special education placement decision making. Neither does the reasonable and prudent parent standard. That decision making ability still lies with the parents, and the foster parents, through the reasonable and prudent parent standard, are not allowed to make those special ed placement decisions. So just to make that clear.
It's a great clarification.
And just so you know, some people are still losing audio.
Oh.
It's in and out.
Okay.
So.
Okay. Thank you, Rita.
Mm-hmm.
Okay. So moving on to adult students, the rights of the parents transfer to the child at the age of 18. So at the age of 18, then the child becomes an adult and starts making their own educational decisions. Parents have access to their adult children's records unless the student indicates in writing that the parents can't have that access.
Relative to special education authorization, as Tim just alluded to, notices must be given to the parent, and the parent has authority to make a lot of decisions related to the IEP in coordination with the other professionals involved. And formal written authorization must be obtained to involve an out-of-home care provider or the caseworker in an IEP meeting or team decision making and planning. It is certainly the recommendation of both Department of Public Instruction and Children and Families that where appropriate, it's helpful to involve both the parent and the out-of-home care provider. You know, the parent may have some contact or very little contact, but no matter how you look at it, the out-of-home care provider is with that kid a good chunk of the day, and the school is with that kid a good chunk of the day. So there's a lot of information to be gathered from all of the parties. So, and generally speaking, parents will go along with where we get into trouble is when we don't have the parent's authority and the child's caseworker just sort of automatically shows up.
Okay, so we have another opportunity for questions if any have come in. No? Okay, so we'll move on. So we're going to wrap up the webinar with a variety of different resources that may assist with the implementation of both the Every Student Succeeds Act and becoming a foster parent. So the documents referenced on this slide are specific to ESSA. The first document was issued jointly by the 2 federal departments to assist states and local agencies in implementing the requirements that became effective December 10th of 2016. Wow, we're already past December 10th of 2017, so
We are.
I have to make that clarification. And the second is the final regulations that were first issued back in May of 2016. They did receive an immense amount of comment and feedback, and so changes were made, and the ones here are the final set. So Tim's going to talk more about resources that are available to foster parents before we wrap up.
So on this slide here, there are 6 websites linked. And of course, you can link directly to these through the presentation that you will have access to in the resources. All 6 of these websites are specific to foster families and adoptive families in Wisconsin. And these are great resources for those foster and adoptive families. So if you, in your work with foster or adoptive families, know of some that need resources or need help, I would encourage you to share any of these resources with them, any of these links. They're all very good.
If I just make one mention about the 4th one down on the list, the DPI with AgGov. This is a website we started basically in response to the ESSA, and there's a lot of helpful information on there, we think. And virtually everything on there is material jointly developed by DPI and Department of Children and Families, for which we are very grateful.
We have a few questions here. One is, do the foster parents receive report cards also? Does the school need signed permission?
So what we had previously said on an earlier slide was that schools cannot share information with out-of-home care providers directly, so without permission. So they can share that information with the caseworkers, and then the caseworkers can share with the foster parents. I will tell you, in practice, my experience was that, yes, the foster parents were provided with those report cards. So I don't know if on the school side of things there were permission forms in place. But it makes sense to have foster parents not only have access to report card information, but also to any sort of Skyward or what's the other? Infinite Campus. Yeah, to the electronic sites that parents would have access to, considering they are in charge of kind of ensuring kids are at school, they're doing well, they're helping with homework. So having that free sharing or the ability to share that information is definitely helpful.
We have another question. IEPs are on legal timelines. We often run into the problem that county workers cannot obtain consent, signature for testing, or even placement, and the child misses out on appropriate educational needs. So that's a statement, not a... I think she wants to address the concern.
If it becomes a significant issue where the parents just won't cooperate or can't be found, then what you want to do is appoint someone, a person acting in the place of the parent, or potentially a surrogate parent. Yeah, if a child is not getting the service they need because the child welfare worker can't find the parent or can't get the information, then other procedures need to be invoked.
Okay. If the child has an IEP and transportation is a related service in the IEP, which district is then responsible for providing the transportation?
I believe it's the school of residence. But like everything else in this process, child welfare wants to help contribute, either directly or through the foster parent.
For the birth parents to speak with the child welfare worker, there's no consent needed. Birth parents can share information with anyone that they choose.
Okay. We have a couple more. Is a consent for release of information required for the bio parents to be able to speak? Okay, that's the same question. So we got that one twice. And the sound is good, and it's like in and out. Okay, and she says she did not get an answer. Please repeat. She says she didn't get Mark's answer. And we don't have the name of who's typing the questions. So if you will resend the question, we're not sure which one belongs to Mark. So if you send that question one more time, we'll address it for you. I'm not sure which one you're referring to because there are no names listed next to the question. Okay. So for now, we can continue on, and once we get that question, we'll break and answer it for you.
Okay, thank you, Rita.
You're welcome.
Tim, you're going to be continuing on?
Yes, this slide is actually a part of the last slide. It was actually, I think it was the second link on the last slide. So we can go past this one here. We'll go to the next slide. The Wisconsin Foster and Adoptive Parent Association. This is a volunteer-based organization that supports and advocates for foster and adoptive parents, and they provide the things that you see there on the screen. Next slide. This is the only international network of foster parents that exists. ifco.info. That's for support for family-based foster care across the world. The next slide is the National Foster Parent Association. And it's self-explanatory. The next one. The Wisconsin Child Welfare Professional Development System. Emily, do you know a little bit about that? Could you speak to that?
I can. So not too long ago, when foster parent training and the type of curriculum that was utilized became mandatory, they also required that the foster parent training be entered into the Wisconsin Child Welfare Professional Development System. So not only are foster parent trainings housed there, but so child welfare worker trainings are there as well, and it really documents the foster parent training that occurs to ensure that the minimum training requirements that Tim mentioned as part of the Chapter 56 DCF, Chapter 56 that is, are completed. So it's basically a way to track those trainings and ensure that they've occurred.
And the next slide is the UW-Milwaukee Child Welfare Partnership. This is actually where the professional development comes from, correct, Emily?
So the Milwaukee Child Welfare Training Partnership has recently been put in charge of all of the foster parent training. So training for other providers don't necessarily go through Milwaukee, but that is definitely where they're housed right now, so to speak. And just to really quickly go back to the WCW PDS, that website does have the 6 hours of foster parent pre-service training online that I believe anyone can access. So if you're interested, you may want to go, and that gives an overview of the child welfare system as well.
And we have some resources for you in the resources folder of this webinar as well. So please access those and make use of those as you see appropriate.
Okay, I think we're going to try and re-answer a couple questions because audio was lost. And so here's the first one. It says, is a consent for release of information required from the bio parents to be able to speak with the CWA or county social worker regarding the IEP? I know you addressed it, but they couldn't hear you.
You bet. So the answer is no. The child or the birth parent can share any information they want with whomever they want.
Okay. And then they would like to know if you can re-answer the question about transportation as a related service in the IEP. They wanted to know who's responsible for providing that transportation, either the school of residence or the school of enrollment. Who's responsible?
It would be the school of residence. But keep in mind, in Wisconsin, residency is based on where the child lives, not where the parent lives.
Okay, and we have one new question. It says, regarding disciplinary action for foster parents, such as a suspension, would it suffice to communicate with just the foster parent, or is it necessary to communicate with all parties, foster parent, bio parent, and social worker?
I would say that first and foremost, it's necessary to communicate that with the caseworker. Obviously, if a child's suspended, they're going home to the foster parent, so certainly they should be involved. And then if in the normal course of your practice you would communicate that to the birth parent, you should continue to do so, because the birth parent is still in charge of that, those educational decisions for the child, and should be, it's best whenever possible to keep everyone in the loop.
Okay.
Yeah, I mean, basically, it's nice for the foster parent to know that, but the school's responsibility, unless there's some intervening court action, is to make sure that the birth parent knows. They're legally responsible for that child.
Yeah. Whatever the foster parent needs to know, the birth parent needs to know, and vice versa. Well, not vice versa, but whatever the foster parent needs to know, the birth parent needs to know. They should know everything. The birth parent should. So.
And I think sometimes the foster parents get put in the role of being the ones to communicate that information to the birth parent. And what we would really encourage is that information come from the school directly, so that the parent continues to feel involved.
Yeah, there's another question about whether consent is required for
Release of information required from bio parents for the school to be able to speak with the CWA or county social worker. So that particular person is rewording the question. So here's the rewording. Is a consent for release of information required for the bio parent for the school to be able to speak with the CWA or county social worker regarding the IEP? So that was just a rewording.
Yes. Regarding the IEP, there would have to be a consent of information. What we talked about earlier was general school information can be shared without a consent. But yeah, if it relates to the IEP, particularly if these child welfare agency is not on the IEP team, a release is required.
Okay, are there any other questions? Okay, here's one here. It says, what if the foster care agency does not provide the school with the birth parent's contact info? What is the school's course of action then?
So I think that we touched on this one, but perhaps it was when the microphone cut out again. But so if birth parent's contact information has not been provided, they should reach out to the child welfare agency to get that information, and or contact the school of origin, because the child, if the child was coming directly from the birth parent's home when they were taken into custody, the school of origin should have the most updated contact information for whom that child resided with. If a child is going from placement to placement, that's likely when the school who was transferring the information maybe had the foster parent down as the contact, and the child welfare worker then would be needing to provide the parent's information for that.
That's very good. I think you just answered this last question, which says, how do we know who the birth parent is and who shares this with the school? So you're saying the social worker.
Yes, and I mentioned earlier in the presentation as well, the education passport that has been created. And we're doing education with the child welfare workers to ensure that they know that it's there, and to make sure that they know that that is a resource for them. And that information should share the birth parents' information as well.
And here we have a comment that says, you are referring to birth or biological parent, but I believe you mean legal parent. Child may be adopted.
Correct. The child may be adopted. And in the case where a child is removed from an adoptive parent, the same standards would apply.
Mm-hmm.
Yeah, wherever we talked about birth parent, just assume that it applies to the adoptive parent.
Mm-hmm. And that's all the questions we have at the moment.
Okay. Any other items that Tim, Mark, or Emily would like to touch on that you felt maybe wasn't completely covered during the webinar time? So we can just give a little bit of time for possibly more questions to come in.
I would add that we are in the process, by we I mean DPI and DCF are in the process of doing some strategic planning together around quite a variety of issues, actually. And one of those relates to the law being pretty open, pretty specific, pretty clear about what information can be shared. Where we want to do some work is in the area of what information must be shared.
Or should.
Or should be shared, yeah. And I will use this as an example. Emily may not totally agree with me, but that's fine. Right now, there is a Department of Children and Families has an administrative rule related to what information has to be shared with a foster parent at the time the child is left in the foster home. It's really two parts. The first part is information. You don't leave the child here without providing this information. The second part is information that can be provided to the foster parent whenever the agency gets it, because sometimes it may take a month or two for the agency to get all the information about a child. I have an interest, at least, in doing a similar type of arrangement, but basically when a child is enrolled in school who's in out-of-home care, it seems to me there is certain information about the child that should be provided to the school, like, immediately. And to a certain extent, what Emily was talking about in terms of the education passport would serve that purpose, maybe with a few changes to the content. But for example, you wouldn't want to leave a kid at school without telling them, certain things about the kid. Like the kid has been victimized, that the kid is allergic to peanuts, whatever it might be, because that kid's going to be spending all day in the school. And the school really needs to know some basic information about the child. One of the issues that we have is that under Wisconsin law, anybody, quote unquote, can enroll a child. So, I mean, it doesn't have to be the parent, it doesn't have to be a guardian, it doesn't have to be the child welfare worker, it can be the out-of-home care provider. So, depending on who enrolls the child, that person's going to have maybe a whole bunch or maybe very little information about the child. So, this is a partnership deal where we've all got to communicate and work together, and so whoever has the information needs to share it, whether it's school to the child welfare agency to the foster parent.
There's school to school.
Or school to school.
I don't disagree that the information, especially if it's a need to know or something very important like a peanut allergy, needs to be shared. Where I think sometimes we rely too heavily on the child welfare agencies is when that information is already documented at the school level, and the federal requirements do say immediately that those records should be transferred, and that's one of the reasons. So the information can come through that channel, and that would be the fastest route for that information to come in most cases.
Is there anything you can share again about the education passport that some of that audio was lost as well?
So the education passport is a form that is generated from the child's case record, which is maintained in the EWISAQUIS system. So that is the electronic Wisconsin statewide automated child welfare information system. It's essentially a database where all case record information is maintained, and that form, the passport itself, pre-fills. So a child has an education tab in the SAQUIS system. Essentially what a child welfare worker needs to do is just go to that education tab. They can then select the option of the education passport. It pre-fills information from the case record into a form that can then be, it's a Word document. It can be printed off and it can be shared with the school district. The issue with the passport is that, like I mentioned before, if a child is new to the system, it takes a while to develop that case record. People are just getting to know information about the child, and so it may not be easily shared for new placements within a short period of time. For kids who have been in care and are maybe just changing placement settings or have a different school that they're attending, then that information can be easily pulled up and printed out to be shared with the school.
Okay, we have a combination of questions here. Anything else on that? Okay. Says, making sure I understand. School records need to be released to the worker who can give records to foster parents. But foster parents can have access to Skyward or Infinite Campus.
With parent permission.
Okay.
Mm-hmm.
Does there need to be written consent from the biological parent for this access?
Yes.
Also, once foster parent has access to this, they have access to prior records from previous years. Is this okay?
If parent permission has been obtained, I don't believe there's anything that would prevent that.
Okay. She says, or can they only have access to records from the period of time that the child is placed with them? It is difficult to limit this access once it has been granted.
Yeah, so once permission is obtained, there really shouldn't be anything that prohibits a foster parent from looking back, and one could even argue that it may be necessary for them to monitor the child's progress to see what happens from year to year. So it's definitely a good thing for them to have information about what's happened prior to coming to their home.
Mm-hmm.
Yeah, and let me just add to that. You can have all the laws you want and all the rules. The fact is you can't cover everything, and any system is dependent on the ethics and judgment of the professionals involved in that system. Out-of-home care providers, whether they're foster parents or therapists in a group home or a residential care center, are professionals. And there's an expectation that people will not, even though they have the opportunity, will not look at information that they shouldn't. And that's part of the training that foster parents get in terms of confidentiality. And I think for the most part it hasn't been a problem, because I think everybody looks at it as professionals.
Mm-hmm. And currently I have no additional questions.
Okay. Any other comments from around the table here, from Emily, Tim, Rita, or Mark? And we have no further questions, so we will end this.
Oh, we
do have another question. See, if we just wait a little bit longer, that's great. Great. Go ahead, Rita.
It says, is there a specific form that is used to obtain permission to share records, Skyward access, etc.? Is there a specific form used to obtain information to share records?
So I know at the Child Welfare Agency level, oftentimes they have a release of information that will permit that redisclosure, and it gets into very specific things. But I would think that at the school level, there would have to be a release of information that identifies those things specifically, or has some sort of broad statement on it. But yes, so whatever the school has that's at its disposal for sharing information.
Awesome.
Okay. Any other questions, Rita?
I have
seeing
none.
any?
Nope, no more at the moment. But if they have additional questions, can you share with them how they could submit them to the team?
Certainly. I'm trying to think exactly how that would be.
Well, what I would say is that well, they have my email. They also have yours. What we have been encouraging through the implementation of ESSA is that if you have questions specific to the information marker I discussed, feel free to use our email addresses and include both of us in that communication. It does help with the creation of the frequently asked questions documents that we are in the process of revising. And then it also just helps us kind of keep a pulse on what kind of issues are coming up that we may need to create other resources or do some education in the field about.
Okay.
Great. That's great to hear, Emily, that you're open to having individuals connect with you on the questions that they have. Also, as I mentioned in the beginning of the webinar, we will be sending out to you as a participant today a link to the recorded presentation along with handouts. And we can also include on there some contact emails, information that you can forward any other questions to as you may come up with those after the webinar today. So again, I would like to thank Mark Mitchell from DPI, Emily Tofty, Tim Baroud, and Rita Fuller for participating and putting this webinar together. Hopefully it was full of beneficial information for you as participants, and we hope that you'll join us again for future webinars. So thank you again for attending, and have a wonderful day.
Thank you. Bye.
Thank you.
Bye-bye.